Okay, welcome. It's attorney Carmiece with another video for you. And today we're going to talk about transferring your business. Leaving a business legacy requires some special attention from you. And a lot of people are doing quite well these days with developing businesses. And I want to make sure that some information is available for you to consider when thinking about transferring assets, making sure a seamless transition occurs from inception of this business and it's included in your estate planning. So let's jump right into this video. Thanks so much. I'm attorney Carmiece Grace, practice in family law and estate planning in Maryland and Washington, D.C. area. I'm a CPA attorney and I love this topic. I love talking about planning, estate planning, protecting your assets, protecting your wealth, because we as a community is growing in that regard. So let's jump right in. So a lot of times people form LLCs and they just, jump on, get a couple documents going, form the LLC, get an EIN, and then they start doing business. And what happens is if this business tends to develop into a substantial asset, meaning that it has contracts, maybe you're into government contracting. That's really hot now, definitely a topic of my interest. But say you're into government contracting and you develop this business and this business explodes and it's doing really well. You have your accountant, you're doing your taxes, but sometimes you might not think about the core documents because it wouldn't come up until it's time for it to come up. And the purpose of this video is to give you this information before you need it, before it's too late. So let's jump into the key documents is what we're going to be talking about today. The key documents that I think you need to have or should have with respect to your businesses, your LLCs, even if you are a C Corp. Let's jump in. And where this merges for me, prior to owning my own firm, I worked as a mergers and acquisitions attorney and dealt with the buying and selling of businesses. So these documents were key, part and parcel to that transfer. And what I'll tell you, first things that I want you to think about. So when you develop an LLC, one of the things you're not thinking about is your marital status. Your marital status can greatly impact your assets. And this asset of yours that you're developing, an LLC, a C Corp, your business is an asset. So you have to plan for it. For instance, I would say for core documents, and the purpose of them is, let me back up a little bit and give you an overview from my perspective. Two instances where we have to value the business. Sometimes we're dealing with a divorce. Sometimes we're dealing with the passing of a loved one in probate. The difference is this asset that you have, typically your LLC is a privately held asset, meaning it's not publicly traded on the stock market whereby someone has valued what the worth is. So unlike other assets, like say if you have a 401k, you can get a statement from your 401k administrator telling you how much is in there. It gives it a valuation. You can get appraisals for homes. They can tell you the value of that asset. If you own stock in Tesla or any Fortune 500 company, any company traded on the stock market, you can just simply look up what the value of the stock is, and it can be then we can then use that valuation. But when it comes to your business, it's a privately held company. And that means you'd have to then, even in the instance of, a death or divorce, someone's going to have to come in and value that asset. You can get ahead of this. You in your documents can, on the front end, tell someone how to value your property, what it should be valued at, in the instance you pass away. If this document, and you, for instance, if you have a C Corp, this would be in your stockholders agreement. It would have provisions in there how to deal with the distribution of this asset, maybe during divorce. I think those things are better dealt with in antenuptial and prenuptial agreements. But definitely when there is a death of one of the stockholders, you can put in that agreement how it should be valued. This sounds benign. This seems far reaching, but once you have to deal with probate, then you're going to have to spend some money. to get a calculation, a valuation done, a simple one, even for, a separation or divorce, they start, 5, 6, 7, 8 grand off the brick. You know what I mean? This is not if you have big assets in your company, like a trucking company where there's a lot of inventory or property. All of those things can really quickly, exponentially expand the need for this valuation. So those documents, again, so we're talking about having key documents. If you are a C Corp, a stockholder agreement, if you are an LLC, an operating agreement. And the reason why people tend to not need these agreements and don't, well, you need them. The reason why you don't need them to conduct business is because the state has by default documents in place that will tell you how to wind down your business, but it doesn't tell you how to value your company. And you could be leaving a lot of work for your legacy to deal with in terms of accepting and taking over the reins. So in your operating agreement, you need to talk about who would be the successor, what happens to you if you pass, what do you want to do if you sell it, how do you evaluate the assets. You got to think ahead about the longevity of this business, especially if it starts to develop and take, flight. Couple things, couple other agreements. We're not going to spend too long, but remember, if you're in a partnership per se, meaning that maybe you're in an LLC and there are other members, you definitely want an operating agreement, but then you also want to consider what happens if one of the partners goes through a divorce. What happens if one of the partners pass away? You have to really think about how to buy back. What you're going to want is the company's going to want the option to buy back those stock. You're going to want to buy back that membership interest. You want to say, okay, because if not, it just is one of, so let's give an example to slow this down a bit. Let me give you an example. So I own a company, and I own the company with 3 other people, and I pass away, and there's no operating agreement. And what happens is my interest in that company, which we don't know the value of in this scenario because we didn't have any documents, is 1/3 of the value of this company. 1/3 of the value, say for easy math, the company's worth $300,000. After we spent money to get a private, calculation done. And now the company has to spend money on that, right? Partners are not going to be happy that we didn't think ahead. And now to fulfill my probate, because my people are going to want to know how much does my mother or aunt or whomever wife own in that business. I know she was a key partner. I know she has a stake in it. I need to know. They're going to want to know. And what's going to happen is that whole business is going to be subject to my probate. You want to protect your business from other people's divorces, your own divorces, and probate. You want to keep your assets away from that. So those are the things we think about, and we can set the process for how the assets will be valued upon death and what happens if there's a divorce. Typically, what you do dealing with divorces, you want your spouses to waive interest in the company, so it's not subject to a litigation. I have a case right now, and I'm representing, a client that has a business, and it's going to be uncomfortable. Maybe if the other side asks him to produce, statements or, information regarding the business, we're going to have to hand that over. And people are like, why is my business in your divorce? You're going to have to think about having, spousal, waivers for interest in the business. And that's when you get into the realm of prenuptial agreements. That's one of the other key documents. So just formation documents, we're looking at the LLC, the operating agreements for the LLCs. We're looking at the stockholder agreements for the C Corps, partnership agreements for the partners. And now we get into dealing with the marital status. Now you want to think about a prenuptial agreement or antenuptial agreement. I have another case where it is saving us a lot of headache that this second marriage did not do what it was supposed to do, but they were married 7, 8 years. My client has a significant business, right? Significant business. And thank goodness she had a prenuptial agreement where it says you're not going to accrue any interest in this business. So now it's time for the divorce. We don't have to worry about someone saying, hey, go ahead and get a valuation on the business. It's the same process, probate and divorce. Go ahead and get a valuation on the business because I got to figure out how much of that interest is marital. You don't want your business caught up in that. So in those instances, this is where we have to deal with prenuptial agreements and antenuptial agreements. There's a lot of flexibility in the agreements. Typically, when people are serious about their business, it's not a you get nothing sort of agreement. It's a thoughtful process as to what would be fair. And you do the best job of thinking about what's fair when cooler heads are prevailing and you're in love. So it's the best time to sit down and talk about what happens if, we're going to give this a go. People are variables, relationships ebb and flow. We're flowing right now. If we need to ebb, how do we do this without a lot of heartache and consternation? Because the hearts are fickle and they do turn. So doing the agreement on the front end, and I'm talking about a prenuptial agreement or antenuptial, which means the difference between the two is simply when you do them. Prenuptial means you did it before you got married, before you said your nuptials. Prenuptial and antenuptial is just you did it after, right? And in these agreements, I would say for working class people, second marriages, you want to think about your retirements, X those out, carve those out. And pretty much you want an agreement that says anything that we acquire together intentionally going forward is marital property. And also you want to decide how to divide that. In this case, where there's a prenuptial agreement, we're going to be in and out. They acquired, some property. The agreement talks about if the marriage does not work, everyone's going to divide that property 50-50 and not leave it up to the courts. This is the type of grown-up conversations we need to have to make sure that you're not held hostage. I don't want people held hostage in marriages. It's voluntary. So if you need to exit, we can exit gracefully. I also don't want your businesses subject to litigation and also to probate, because your loved ones are going through enough as it is. If you need a successor, we want these documents in place. We want them organized so that it's already a difficult time dealing with a significant loss of a loved one. People's heads are just not there, right? So you want to plan as much as possible. And then I get the big question all the time, should I put my interest in, I'm going to try and see if I could, wait, hold on, guys. I'm trying to see. I never get to say hi to people that take time to hang out with me for a little bit while I do my little videos. And I want to see who they are to say hello, but I'm so not good at this StreamYard yet. So just give me a second. I'm going to try and figure this out. But thank you so much for my humble viewership. But we're at midday, so I understand. But I wanted to get it in early. But so the final question that I get is about, should I put my business in a trust? And should I put it in a revocable trust or irrevocable trust? I say yes. I think a revocable living trust is fine. They have different goals. So the purpose of putting your interest, your business in a trust, right, would be to avoid probate. Putting your business in a trust, your interest in a trust, we could just move past all this probate and valuation stuff, right? And skip that. So I really do think that if you do have a business, you can easily transfer that interest into a trust. Like you can transfer houses, cars. You would transfer and assign. It would be an assignment. Attorney like myself could draft an assignment, and we could assign your interest from you personally to your interest in your trust. So definitely highly advisable. Now, whether you want to move on to get an irrevocable trust, that is a whole nother animal that's designed to avoid taxes. If you are not pushing, over 5 million, 10 million, the thresholds are really high. I don't think it's a big concern. If you are, let's have a conversation. Now, with a lot of people doing government contracts, people are getting there, right? So it's not like it's unattainable. It's not pie in the sky, 10, 12 million. People are making money. But I'm going to tell you that other vehicle, you lose control. You're not going to have control of the assets that are in that trust. So a lot of times that's a concern. People tend to use those trusts more so if they are planning for long-term Medicaid care, Medicaid. It's the Medicaid trust. So if you're planning for long-term care, I'll tell you one of the things that we run into is people wait too long. You need 60 months to transfer those assets over. So that's just a little mind dump there. So overall, to wrap this up, key things that I want you to have in place for your business beyond your certificate of incorporation or formation and an EIN number is if your business is developing, we're going to need to have more substantial corporate documents. Okay. Then you're going to consider your marital status, whether you need prenuptial or antenuptial agreements, and have a conversation as to what that interest may be worth. You can, for instance, it would sound like this. Here's an example. You could say, well, I want you to waive any you won't accrue any marital interest in this business. But however, if we're married for 10 years, I will give you 30% or 25% of whatever I have, whatever I own in the company, and we will use ABC method to value the company at that time. That's what a real clause, a real negotiated clause sounds like. Not like you ain't gonna get none of my business, sign it. No, it's not that. It's saying I don't want it caught up in litigation, but let's be reasonable and let's come up with something that works. A lot of prenuptial agreements have real terms. If we're married for X amount of years, you'll get the house. Whatever you guys think is fair, but it's usually not just a bare bones agreement, but it could be. I mean, it could just say whatever we build together is what we'll divide together. And then, you have to think about some other areas of alimony and things like that. So prenuptial agreements, spousal waivers, and revocable living trusts will be documents that you should really consider. Okay, so that's all I have today on this topic. I know it sounds kind of dry, but I'm going to tell you, I promise you, I'm talking to you from the future. If you are able to focus on this, get this done, you will have your stuff locked down together and be able to hand a folder over to an attorney. Your successor who's going to be taking care of your affairs will be well suited to say, look, I don't know, but here's all the stuff that my parent did or spouse did. And they can open up that folder with joy and say, yes, we can work with this. I can take care of this. No problem. That's the place we want to be. So hopefully this information was helpful to you. If you have any questions, always feel free. You can send me an email with questions. I'll address them. And actually, what I'm going to do is I'm going to take a pause for the cause real quick, but I'm going to come back and I'm going to answer a question that I received. I promised on my shows, if I got questions that I think a lot of people have, that I'll go ahead and answer them. This one is on family law, and there's a lot of family law going on. I'm putting information out about estate planning because I want you guys to do more estate planning, but we're doing a lot of family law. So hold on one sec, and then I am going to, I don't even know how to do this. Hold on real quick. Hold on. Okay, I just wanted there to be a little break so I can restart. Okay, I'm back, y'all. Now we talking family law. Okay, what's going down in these streets? I got a couple things that I'm really concerned about, and that's going to be these high conflict custody battles. Our millennials are, or Gen Zs, I think it's the Gen Zs. Gen Zs has more millennials, younger than me. I'm auntie to them. One thing that's going on with these babies out here is these high conflict cases and the toxicity that these kids are being raised in at such tender ages. It's just a grave concern of mine. There's a lot of arguing. There's a lot of back and forth. There's a lot of fighting, and these kids are 2, 3, 4 years old. And I am really concerned about what is to come for them. So please think about healing, teaching our kids about emotional intelligence. That's what I would say. Please invest in teaching our youngsters, ourselves, or we're learning about this now. Mindfulness, we're doing meditation more, people are going to therapy more. Please enable your children to learn how to deal with their emotions. That's what we're dealing with all these high school shootings. People are not dealing, life is hard. It's pressing everybody out all the time. And our young people are feeling a lot more stress. I feel like they're really stressed out, right? Their parents are stressed out. These relationships are breaking down. They're fighting during exchanges. Y'all, it's sloppy out here, okay? So only thing I can offer there is that we take care of ourselves emotionally and teach our children to do the same. So the question that I got recently was, my spouse has received a settlement from a case regarding an injury, and we are in the midst of a divorce. And will I be entitled to any part of that settlement? And I believe that he has put it in a trust. Okay, so this question I got. All right, got this question in. And I thought it was a really good question because it brought up a couple of points that I think a lot of people deal with. So first off, the first thing that comes to mind is dissipation. The concept of dissipation in a divorce is when somebody intentionally tries to hide money to avoid paying money out in a divorce settlement. Generally, that's called dissipation. And what happens is, if we're able to identify that this asset did exist and that it no longer exists and it was not used for the benefit of the marriage, then the court will still, enter an award for the benefit of the person who suffered the loss for the money. So for instance, somebody wins the lottery, or they win, no, and we're going to go with the scenario. They get the settlement from the injury. Say they get $1 million from the settlement, and you didn't know about it really. You knew that there was a case going on. You knew the person was in treatment, but you never saw the check. You don't know if it's settled. You don't know how much. You don't know where the check went, but you know that there was something going on. Person was going to physical therapy for years, right? Now, the fact that you know that this asset exists gives you a headway, and that's a key. You have to know financially what's going on in your marriage. I know it's really cute to be a kept woman or a kept spouse, and they pay 100% of the bills. Yes, but know still financially what's going on in your household, because when you say, oh, the person took care of everything and I don't know anything, well, we can't just go around knocking on everybody's door looking for assets. We're going to need a clue, right? So the fact in this scenario that you know it exists is good. Second part of it is you'd be able during your litigation to request information about this settlement and the status of it, right? If you know where bank accounts exist, people typically are not they're not getting $1 million in cash. They are going to receive a check. So you're going to want to know where your spouse banks, right? Going to want to kind of know who the case was against. At least we could, send a subpoena out to whoever they were suing, right? Whoever it was involved, maybe the insurance company or whomever the players were. Gotta know enough. Now, the interesting part of this question is, because it's a personal injury matter, is that marital property? Is a personal injury settlement marital property? And I like that question because it was intriguing. And parts of it, yes, and parts of it are no. Are a no. So there's parts of a settlement that relate to lost wages, things like that. And that portion I would consider, and I would think, I don't know for each state, but intuitively we would look into this, that part would be marital. The part that's pain and suffering, right? That is personal to the person, right? Now, there could be, I don't know if there's so the part that's pain and suffering, that's personal, the part that's loss of future income, things like that, that could be considered marital property. So let's go on. So it depends on how the settlement is structured, okay? That's the bottom line. Depends on how the settlement is structured, and you need to look at that to determine if any parts of it is marital, and probably there's going to be at least some part that is, but it all depends on how it's structured. Then what about the part if they put it in a trust? Again, that could be a transfer that was intentionally done to avoid paying out to the spouse pursuant, in the midst of divorce. So that could be a dissipation transfer. And again, there would be some record of this money moving from one place to the other, right? Moving from one bank account to another bank account. Because although you have a trust, the trust is pieces of paper. They actually hold assets that exist in the world. So the trust, there would be a bank account in the name of the trust. So unless you put the money in a safety deposit box, you would still see a withdrawal from a bank account, right? So there would be a personal bank account where the money was deposited into. Now, whether this person could have the settlement paid directly to a trust, that could get savvy. That could be interesting. Again, you're going to have to know that the asset exists. So I think that's a really good question. And I think the takeaway there is knowing about what's going on in your household financially. You're going to have to know. You can't be an ostrich about it. And if you don't know, we can't help as much. You'll be spending a lot of money with forensic accounting. So that was the question that I got, and I wanted to give an answer. As in always, attorneys, we can't give you exact answers because there are variables that always exist. But generally, do not lose too much sleep about people trying to hide large sums of money. They usually leave large footprints that are easily traceable. So as a former auditor, I don't lose a lot of sleep in terms of not being able to find assets. Now, someone that has a cash and carry business, that they're collecting cash only, that's a bit more difficult to keep a hold of. That's why people like to do business in cash. So anyway, that's it. I'm going to wrap it up. I'm going to leave it there. Thanks so much for tuning in. Thanks so much for hanging out with me. Oh my goodness. Okay, I've got to figure this out. So we got 2 people. I don't know, guys. Thank you so much for tuning in with me. Thank you so much for spending a few moments with me. If you have any comments or questions, you can free to post them. If not, email me. But I'm going to log off, and then I'm going to get someone to help me to figure out how do I see who you guys are. It's got to be the way to do it. I'll learn. I'll grow with the platform. But thanks so much for tuning in. Talk to you later. Bye.